Okay, so let's kick things off with a little thought experiment. Imagine you pour your life savings into an investment, all based on an expert report that says it's a sure thing. But then, you find out that report was completely, utterly wrong. You've lost everything. So, who's to blame? Well, today we're cracking open a real-life legal mystery that answered that exact question, and, in the process, created one of the most important legal tests we have. Right. So our story begins with what looks like a rock-solid fact. You've got a public company, and a team of expert auditors goes through their books. They come back with a clean bill of health saying, yep, this company is making a healthy profit, everything looks great. So, along comes an investor. They see this official glowing report from the experts and think, okay, this is a golden opportunity. They trust the numbers, and they make a massive move, pouring millions into the company by buying up its shares. On the surface, it's a totally logical, data-driven decision. And here is the big twist. That glowing report, that clean bill of health, it wasn't just a little off. It was dead wrong. The company wasn't making a profit at all. It was actually losing a ton of money. Just like that, the investor's money has vanished. So the multi-million-dollar question is, who has to pay for this colossal mistake? Now, this isn't just some made-up story. This is the real-life drama behind a landmark case from 1990 called Caparo Industries versus Dickman. It was such a costly and confusing mistake that it actually forced the highest court in the land to come up with a whole new way to figure out who's to blame in situations like this. So let's quickly meet our cast of characters. First, you've got Caparo Industries, our optimistic investor. Then there's Fidelity PLC, the company that looked so good on paper. And finally, you have Dickman, the firm of auditors who wrote the report. The problem, in a nutshell, was that the audit told a story of profit when the reality was a big, fat loss. The courts had a real problem on their hands here. This exact scenario, an outside investor who never met the auditors, suing them for a bad report, it was brand new. It was uncharted territory. And in law, when you get a situation like this, it's called a novel case. With no existing rule book to follow, the judges had to basically invent a way forward. At the absolute core of this entire puzzle is a fundamental legal idea called a duty of care. Think of it as the first hurdle in any negligence claim. Before you can argue anything else, you have to prove that the person you're suing had a legal obligation in the first place to act carefully towards you to avoid causing harm. So, to figure out this tricky question, did the auditors owe a duty of care to some random investor they'd never even heard of? The judges created a brand new tool designed specifically for these novel, confusing situations, and it became known, famously, as the Caparo test. All right, so what is this test? Well, think of it as a three-part investigation, or a checklist. To prove that a duty of care exists in a completely new situation, you have to be able to tick all three boxes. It's an all-or-nothing deal. And here they are, the three big questions. Number 1, was the harm that happened reasonably foreseeable? Number 2, was there a relationship of proximity, a closeness between the parties? And number 3, the final check, is it fair, just, and reasonable for the law to impose a duty in this situation? Let's break that down. First up, foreseeability. This is an objective test. The court asks, would a reasonable person, in this case, a reasonable auditor, have been able to predict that if their audit was wrong, someone, somewhere, an investor, might rely on it and lose a bunch of money? And in this case, yeah, probably. It's pretty foreseeable that people look at public audit reports. So, check 1. Now, part 2, proximity. And this is where things get really, really interesting. Proximity doesn't just mean you were physically near each other. It means, was there a close and direct relationship? Did the auditor know this specific investor was going to use their report? Did they prepare it for them? Was there any kind of connection at all? And finally, the third step. This is kind of like the court's big picture public policy safety net. Even if the harm was foreseeable, and even if there was some kind of proximity, the court takes a step back and asks, is it actually a good idea for the law to do this? They worry about things like the floodgates argument. Would making auditors liable to every potential investor in the world open the floodgates to a tidal wave of lawsuits that could make their job impossible? So, with these three questions on the table, the court ran the facts of the Caparo case through the test. In the entire case, all those millions of dollars, it all came down to just one part of this test. The verdict was, well, it was surprising.
And here it is. The final decision from the highest court was that the auditors, Dickman, owed no duty of care to the investor, Caparo. That's right. The investor who lost millions based on a faulty report had no legal comeback against the people who wrote it. So you have to be asking, how on earth is that possible? Why?
This right here is the reason why. It all came down to that proximity test. The court drew a really clear line. They said, look, the auditors had a direct relationship with Fidelity's existing shareholders. The whole purpose of the audit was for them, to help them run their company. But Caparo, they were a total outsider, a potential investor. The auditors had no relationship with them, didn't know they existed, and certainly didn't prepare the report for them. That complete lack of connection was the killer blow to Caparo's case. And this quote from the judgment really says it all. The purpose of the audit was incredibly specific. It was a tool for the existing shareholders to use at their general meetings. It was never intended to be a piece of investment advice for the general public. The purpose of the document defined who the relationship was with, and Caparo was simply not in that circle. But hold on, because the story doesn't stop in 1990. Like any good legal principle, the Caparo test itself has evolved over the years. The law doesn't just stand still, it gets refined. So let's fast forward a few decades, all the way to a 2018 case called Robinson. This case didn't involve auditors, but it gave the Supreme Court a chance to take a fresh look at the Caparo test and clarify exactly when and how we should be using it today. And the big update is this. The court in Robinson made it clear that the Caparo test isn't the starting point for every negligence case. It's become a much more specialized tool. You only bring it out of the toolbox for situations that are truly novel, where the courts are sailing in completely uncharted waters with no map to guide them. So the way courts think about it now is much more cautious. It's what they call an incremental approach. Step 1, they look to see if there's already an existing case, a precedent that decides the issue. If not, step 2, they try to find a close analogy in a previous case. It's only if they're really breaking new ground, with no precedent or analogy in sight, that they will then, maybe, use the 3-part Caparo test to decide whether to extend the law. Okay, so let's do a quick recap of this whole legal journey. What are the big takeaways? First, duty of care is always the starting point, the first hurdle in negligence. Second, the Caparo test, with its 3 parts of foreseeability, proximity, and fairness, is the special tool for brand new legal situations. Third, in the original Caparo case, it all fell apart on the issue of proximity, the lack of a close relationship. And finally, the modern approach is much more cautious. Courts build on existing law first and only use the Caparo test as a last resort for truly novel cases. And this all leaves us with a huge, fascinating question for our own time. We live in a world that is just flooded with data, expert analysis, online reviews, and public reports. The central idea from Caparo is more important than ever. It forces us to stop and ask, who was this information really created for? And ultimately, who bears the responsibility for the decisions we make based on it? Something to think about.